air mass meeting here and creating these thunderstorms. Okay, so just you need to be aware of these things. Now moving forward, right to property. Now you will say right to property, it comes under polity. Now why I am incorporating it here? There might be a reason for that. Remember one thing. If something is being asked from the polity, there is a possibility that Supreme Court might have made a verdict or a statement on that particular thing. Okay. Recently, Supreme Court made a remark that right to property is not just a constitutional right, but also a human right. And it comprises of 7 basic implicit rights. So that's why this particular topic became important for your exam. Now, how many questions can be asked from it? In the state PCS exam, a lot number of times, a question has been asked that right to property is a fundamental right, it is a statutory right, it is a legal right, or it is a constitutional right. What happened prior 1978, before the 44th Constitutional Amendment Act 1978, I might have mentioned these things somewhere here. But first, let's get our insight. When the Constitution was framed, there was an incorporation of fundamental rights. Achha, let me ask you a question. Fundamental rights, for the first time, they were mentioned in which report? You all might be aware of the Nehru Report of 1928, when for the first time, Indians, on their initiative, they framed a constitutional framework for the functioning of Indian polity. Because Lord Birkenhead, the Secretary of State of Britain, he made a very provocative statement that Indians are always fighting on their own. They are always fighting for their mutual rights and something, be it the separate electorates, be it on the caste or communal rights. They won't be ever be able to come up with a unified constitutional framework. They won't ever be able, even if given authority also. Let's say the British said that even if we make India independent, the Indians are not in a mental condition to come up with their constitutional framework. They won't be able to frame a constitution for themselves because there are communal fringes, they are communally divided, they are religiously divided, they are divided on linguistics, languages, religion, region, ethnicity. So much of diversity is there in India. So it is not possible for the Indians to rule themselves, to govern themselves, to come up with a unified statement. See, India doesn't even have a national language. No doubt we are having 2 official languages. One is the English and the other one is Hindi. But if I ask you, which is the interlinking language of India? Interlinking language is completely different from the notion of our national language. Interlinking means India is the land of diversity. If I ask you how many scheduled languages are there? There are around how many scheduled languages? 22 scheduled languages as mentioned in the 8th schedule of the Constitution. Then there are how many languages of India? Schedule means officially recognized languages. That okay, these are the languages. But there are many other languages also. Some regional language, Rajasthani is there, Marwadi is there, Gujarati people are there speaking Hindi in their different varied version, completely different from Hindi. In South, you are having so many of the classical languages. There is Telugu, there is Tamil, there is Kannada, then there is Malayalam. 4 of the 4 classical languages, they belong to the entire southern region only. Then there is Odia from the eastern state of Odisha. But from the north, we don't even have a classical language. Just one Sanskrit is there, but Sanskrit was spoken all over India at some period of time. Hindi is not even a classical language. Let's say in the land of diversity, India is a land of diversity. We don't even have a national language or common language. We use English as an interlinking languages. Because at one phase of time, for around 190 years, Britain used to rule India. And they used the language English. So English was a common factor. English was a common language that was used for the official purposes and everything. So English became very popular all over the Indian subcontinent, be it Pakistan, be it Bangladesh, be it India, be it Myanmar or anywhere. So we opted for common interlinking languages. If we are talking, let's say, use Hindi, Telugu, Tamil or any one particular Indian language as the national language, then there will be resistance from the other parts. Let's say someone comes up with a proposition that since Bengali is spoken by a vast proportion of people, why not to make Bengali the national language of India? Then the people from Rajasthan, UP, Madhya Pradesh, they will say we people are fools or idiots. We are speaking Hindi. Hindi is spoken by a larger proportion of people. Why opt for Bengali? We don't understand Bengali. If we say, let's make Telugu the national language of India, then even from the south, someone will say that Malayalam should be made. Someone will say that Tamil is more ancient. It was used as the language of the gods by Shiva and something. Okay. So India being the land of diversity, it is very difficult to get a unified framework. So forget about language. Just come to constitution. It was very difficult to get a constitution framed. So I asked you a simple question. When it was the first time when Indians came up with the unified constitutional framework, it happened in 1928 when Lord Birkenhead, in 1927 exactly, Lord Birkenhead made a challenge. In history, when you will be studying modern Indian history, you will study that Birkenhead challenge. Lord Birkenhead, the Secretary of State, the SOS, he made a provocative statement that Indians won't be able to come up with their own constitutional framework. In response to that, in 1928, a committee was formed under the chairmanship of Motilal Nehru, who was the father of Jawaharlal Nehru, to come up with a unified constitutional framework. And the particular report that was submitted was known as the Nehru Report. Okay. In Nehru Report, for the first time, 19 fundamental rights were explicitly mentioned. This question has been asked on many occasions. How many fundamental rights were mentioned in the Nehru Report? Okay. Answer will be 19. When Constitution was adopted, in our Constitution, we opted for a separate segment, that is part 3, as fundamental rights. Fundamental rights means those rights which are granted to the citizens of India as a very fundamental basis. In case of violation of these particular rights, which are clubbed together as fundamental rights, you can approach Supreme Court or High Court. And the right to approach Supreme Court for the violation of fundamental right, what itself regarded a fundamental right under Article 32. So this is a very interesting fact. The right to approach Supreme Court is a fundamental right, definitely. Right to constitutional remedy under Article 32. So, in those fundamental rights, which are covered from Article 12 to Article 35, under the broad framework of Part 3 of the Indian Constitution, the entire set of rights that are granted to the Indian citizens as well as the Indian residents, okay, these rights are known as collectively as fundamental rights. Why I'm talking about polity? Because right to property came in news, and while we adopted for the Constitution, under Article 19(1)(f), there was a right by the name of right to property. Like everyone is entitled to have his own property, and the state cannot take his property from him. Are you getting my point? That was known as the right to property, and it was incorporated under Article 19(1), right of speech and expression, right of freedom, basically you can call it. Okay. Under Article 19(1), right to property was explicitly mentioned. But what happened? Post-independence, there were certain infrastructural development works undertaken by the government of India. Let's say government started making roads, government started making railway construction, government started making airports. And see, the government cannot undertake infrastructural development projects in space. Okay, they need land for it, definitely. And if you ask that who owns the land, land is basically owned by someone or the other. Either the nature will own the land, or you as a private individual will own the land. If there is a land, either it will belong to a private individual or it won't be owned by anyone. If a land is not owned by anyone, it may be called a natural land. It is owned by the nature. So government proposes its stake on every natural land, on its defined territory. Indian subcontinent, India is there. If you look at the map of India, so there will be a lot of land or properties which might be owned by individuals, which are known as a private properties, okay, private land. So those part of land which are not owned by any private individual, be it mountains, be it rivers, be it some streams, be it waterfalls, these all geographical territories, they will be ultimately owned by nature. Nature means here the legal entitlement will go to state, okay. Now the government is not going to build road on mountains, sometimes, but not at all times, okay. If government has to propose for an expressway, for some any kind of railway network, any kind of port network, or any infrastructural connectivity, something like that, so definitely it has to do that on land only. So there might be a possibility. You might be aware of the fact also. Let's say there are 4 cities, okay. 4 or 5 cities are there, and government decides to develop a kind of infrastructural corridor or something like a kind of a corridor connecting all the 4 important cities. There are many such corridors, like the golden quadrilateral project is there. There are many projects are going on, diamond and something like that, forget about it. Important thing is that government decides to connect these 4 cities. So definitely they will be finding the least possible connectivity route, just as to save the time and fuel and everything like that. Okay, these routes are proposed, and government decides that we will lay some expressways, multi-lanes, or railway network. There might be a possibility while laying down this route, it may come through some private land also. Okay, there might be some farm, there might be some agricultural land, there might be some private property. So what government will do, it is not possible for government to make road like this, that okay, this private property is there, we will make like this, then this dancing ones. It is not possible. Government will try, for economic reasons, they will try to do the direct connectivity. So the government says that okay, the private property which belongs to a particular person over here, we will give you some compensation. You shift to some other place, we will give you the monetary compensation, or we will allot you some other part of the land, but just leave this place. Then what used to happen, earlier there was something called the right to property. Okay, and right to property was explicitly mentioned under the fundamental right. So people used to go directly to Supreme Court. People will say that the state is violating our right to property. Now state got its own compulsion. State needs to acquire the land for the sake of infrastructural development. Okay, but these people were again and again going to court, installing the entire project and putting the economic development in jeopardy. So the government came up with a proposition that why not to simply put, first of all, they came up with Schedule 9. They say if we are, and one more thing was there. It's not just about the infrastructural development project. One thing was more there, that prior to independence, a large proportion of lands, be it the agricultural land or be it any other sort of lands, they were basically owned by jamidars or jagirdars. Okay, you all might be aware of the Bhudan movement that was initiated by Vinoba Bhave, who was a ardent follower of Mahatma Gandhi. So what Vinoba Bhave used to propose under his Bhudan movement or Bhudan Antyodaya scheme, something he came up with, he said those people who are having a large proportion of the land, they should surrender some of their land to the government so that the government can redistribute it to the landless peasants. Those people who are not having any land. There should be some kind of a socialist equitable distribution of land. Okay. So what was happening, whenever such demands were made by any of the social reformers, some people were very good by nature. They used to give their land on their own, okay, for the sake of philanthropy and something. But man by his very nature is driven by his self-interest. That is the basic human psychology. Most of the men, they won't be comfortable with this idea. They will say that it is the hard-earned land and wealth and acquisitions by our forefathers, and Indians especially, they have a affiliation to their ancestral property. They were not willing to part with their lands. How much compensation they were allotted. So when the government was saying that we have opted for a socialistic distribution of land and wealth, why don't you donate your land to government? So when state was trying to acquire the land for them, for some reason, these jamidars and everyone like that, there was an abolition of Jamidari Act and something, that the jamidars won't be held the repository of the lands. These lands will be acquired by the state. So even the jamidars used to approach to court that it is a violation of our fundamental right. So to come over all these obstacles, the government came up with Schedule 9. And it said that whatever amendments or whatever land tenancy acts we are undertaking under the Schedule 9, they won't be challenged in court. So that's why sometime a question is asked that what is the significance of Schedule 9 of the Indian Constitution? Because see, original Constitution only had 8 schedules, okay? And right now you are having 12 schedules. That means 4 schedules were added after independence. Schedule 9, 10, 11 and 12. You all are aware that Schedule 11 and 12 that were added by the 73rd and the 74th Constitutional Amendment Acts when we came up with the Panchayat, or the, you can call the, what do we call it, local self-government, something like that, okay? Part 9 and Part 9A of the Constitution, local self-government, municipality, village panchayats and everything. So for giving authorities and power to these village panchayats as well as to municipalities, we came up with Schedule 11 and 12, where some subjects are defined over which the panchayats will be having jurisdiction upon. These are Schedule 11 and 12. But what about Schedule 9 and 10? Schedule 9 was about certain land tenancy reforms. Okay, land tenancy reform means abolition of jamidari, acquisition of the land, something where the government was trying to take stake over land. Okay, stake over land. Government was trying to take or acquire the land. So certain acts were passed for that with regard to abolition of jamidari also, as well as the land reform also. Because of our first 5-year plan, it incorporated development of agricultural sector as the basic initiative. Okay, so we have to undertake some very big, large-scale agricultural reforms, and abolition of jamidari was a crucial component for it. We have to take lands from the Jamidars, abolish all the Jamidari acts. We have to redistribute the land ceiling acts were passed. So much of the reform was done in the land sector. And right to property was a part of fundamental right. It became a very big hurdle and obstacle for the government. So government came up with this scheme. They came up with Schedule 9 and they say whatever land tenancy acts we are passing, we will put it under Schedule 9. And those acts which are put under Schedule 9, they won't be challenged under, in the Supreme Court. Okay. And Supreme Court also agreed to it because it is for the national welfare. Okay. Every time government will make a certain reform act, they may be challenged by someone or the other. Okay. So what happened? First we came up with this Schedule 9. One proposition is that. Now what happened in the year 1970, in the year 1978, when the Morarji Desai government, Janata Party government came into rule, they came up with the 44th Constitutional Amendment Act. Okay. 44th Constitutional Amendment of the 1978, it came, and what it did, it removed right to property from Article 19(1)(f) as a fundamental right, and it placed it somewhere under Article 300A. Now what happens? You say, what is the objective of removing right to property from Article 19(1) and placing it under 300A? Still it is a part of Constitution, but there was a very big difference. When something is placed under Part 3 of the Constitution, it makes it a fundamental right. That means in case of the violation of a fundamental right, you can approach to Supreme Court or a High Court also under Article 226. But the difference is that if you are approaching it to Supreme Court, it is provided under the fundamental right itself. Article 32 itself comes as a fundamental right. That means your right to move to Supreme Court for the violation of a fundamental right is itself a fundamental right. But Article 226, it is not mentioned in the Part 3. It is somewhere else in the Constitution. So that's why any such right which is mentioned anywhere in the Constitution is known as a constitutional right. But if that right is mentioned under Part 3 of the Constitution, then it is a fundamental right. Now what Morarji Desai government did, it moved this particular right to property from Article 19(1)(f), that was Part 3 of the Constitution, that made it a fundamental right, to Article 300A. Now this right to property, it became a constitutional right. You have to remember this thing. Now let me ask you a question. Right to vote. Like let's say right to vote, in one way or the other, it is mentioned in somewhere in Article 326. In the form of adult franchisee. Like everyone who is 18 or above the years of 18, he is entitled to vote. Okay. That gives you the right to vote. Okay. Like no one can stop you from voting. In case your name appears on the electoral college, you are above the age of 18 years and you belong to a particular constituency as prescribed by the Election Commission of India under the Representation of People Act. Okay. These things, criteria are mentioned. So you will be granted a right to vote. But if you are not allowed to vote, you cannot go to court for that because it is not incorporated into Part 3 of the Constitution. But still it is mentioned somewhere in the Constitution, making it a constitutional right. Got it? In a similar way, right to property is right now a constitutional right. So most of the time, people or private entities come in confrontation with the government with regard to the securement of their rights, and right to property being one of them. This is all about the basic. Now come to the current stats. Okay, I have taught you the entire part of polity from this particular topic. Come to this thing, that Supreme Court has ruled that compulsory acquisition of property without proper procedures and fair compensation is unconstitutional in nature, affirming the right to private property as a constitutional and a human right. First of all, Supreme Court here has made a noting that right to property without proper procedures. If proper procedures are followed, by proper procedure you mean a monetary compensation needs to be given to the person whose land is acquired by the state. The other thing is that in case a monetary compensation is not offered, a similar land should be granted to that particular entity at some other place. Let's say government comes up with a proposal for a dam. We need to build a dam and there are some inhabitants which are occupying the land. Some families might be living over there. But what happens once a dam is made, entire water body like a lake kind of a thing will be formed at the back of the dam in order to secure the water. Okay, securing the water body, that's the purpose of the dam. Okay, so in case the family doesn't move from there, it will submerge into the water. So government says in advance that you people relocate to somewhere. We will pay you the compensation, either the monetary compensation or we will relocate you. we will rehabilitate you at some other suitable place, whatever is available. So sometimes what happens, the government is giving them the assurance, but not it is implementing it in practical terms. It assures them that, okay, you rehabilitate from them. And these people start living in camps and somewhere. Okay. And the government officials engaged in some bribery, violating the work ethics and everything, they fail to compensate these people. So in that case, there is a public resentment. Sometimes there are riots also. Sometimes there are clashes with the police officers and everything. Protests by the people that, okay, we have been denied. And it mostly happens in case of the tribal rights. In the tribal regions, in the forest region and all, whenever government is coming up with some stringent act, government is coming up with some infrastructure development project, government is coming with some establishment of a factory or something like that, or coming up with a forest right act, then these tribal people who were traditionally dependent on the minor forest produce, they are being denied of their certain tribal customary rights. They are, assured by the state that we will rehabilitate you somewhere. But the government fails to keep its promise. And that's why most of the time these tribals turn against the state and known as Naxals. Naxalism problem, which is faced by the entire red corridor, that is the eastern states of India penetrated till Andhra Pradesh, from West Bengal, Bihar, Odisha, everywhere, especially the eastern regions, this red corridor gets formed. It is basically based in Chhattisgarh, Dandaka Randiya region, Bastar region. Okay. So it was a result of these policies of the state only. Land acquisition, a denial of the customary tribal rights. People were snatched away of their lands and not provided sufficient land rehabilitation, whatever was there. So basically it was a violation of the human right. People were denied of their basic existence. So that's the significance of the Supreme Court ruling here. It said that the right of this private property, compulsory acquisition of the property without the proper procedures or the fair compensation is unconstitutional in nature. It goes against the basic premises of the Constitution. That's why Supreme Court was affirming the right to private property here as a constitutional and a human right. Okay. So the question can be asked, as per the recent Supreme Court ruling, right to property is constitutional right as well as a human right. As they stated that 300A has been characterized both as a constitutional and a human right. And what do you understand by 300A? No person shall be deprived of his property save by authority of law. It is only by the law, if a law is made, that a person should be denied of his property, in lieu of which he or she will be provided an adequate amount of monetary compensation or some degree of rehabilitation. If those proper procedures are violated, in that case, that particular acquisition of the land, it will be regarded unconstitutional. Okay, so that was all about right to property. Now moving forward to this particular topic only, what are the 7 or 8 basic rights which are implicit to right to property, which Supreme Court explicitly mentioned while making its noting. The Supreme Court laid down there are 7 basic procedural rights of private citizens which constitute the real content of right to property. See, for the first time it is happening that Supreme Court is explicitly defining right to property. Right to property since ages, since this 1978 amendment happened, it has remained a very vague or a very subjective notion. That's why they have been asking this question in competitive exam, and people usually get confused whether it is a statutory right, whether it is a constitutional or a legal right. Some state boards have even recognized it as a legal right. But legal and constitutional are somewhat same. But there is one basic difference to it. There is something called legal. Legal means which is allowed by law. Okay. Now legal can be segregated into constitutional and the other being statutory. Got it? Legal can be classified into constitutional or statutory. By constitutional, let's say legal right. Now here comes your constitutional right, and here is statutory right. So if something is constitutional, then definitely it is legal. If something is statutory, then also it is legal. Okay. But what is the difference between constitutional right and a statutory right? Constitutional right means a right which is mentioned in the Constitution anywhere. So that's why fundamental right, can be classified as one part of constitutional rights, because fundamental rights are a part of constitution, and if something it is mentioned in the constitution, it becomes a constitutional right. But fundamental right incorporated under part 3 of the constitution, they are a segment of constitutional right, not entirely the constitutional right. It is a broader term, it is a specific term. Okay, and the other point may be like non-fundamental rights, those rights which are not fundamental but it's still constitutional. Okay, then the one part is and what is the example of this? Article 300A, Article 326, that is the right to vote, right to have the property. Fundamental right, you all are aware, right to speech and expression, right to religious belief. Okay, right against like the abolition of the titles, right to constitutional remedies. So many fundamental rights are there that you might have studied in your polity segment. Then comes your statutory rights, those rights which are guaranteed or assured by a statute. Okay, and what do you mean by statute? Statute means simply an act of parliament. Okay, like let's say the government comes up with the statute of something like a domestic violence act. Okay, and domestic violence act says that if a husband and a wife who are staying together and a wife is subjected to some kind of a mental or a physical torture by the husband, she can approach to the court. So these things are mentioned especially in the Domestic Violence Act. Okay, so Domestic Violence Act is not mentioned in the Constitution, but the right which is given to the woman to approach to the court in case of violation of some of her conjugal rights or something like that, and it is covered under the definition of the domestic violence, she can approach to court or any law enforcement agency, it will be regarded as statutory right. Right to information. Okay, there is a right called right to information. Which particular right it may be? It is definitely a statutory right. And why I clubbed it under the statutory right? Because right to information was guaranteed by the Right to Information Act of 2005. In 2005, you all are aware there was a right to information. No doubt it may be implicitly a part of any of the fundamental right, but explicitly right to information comes from the Right to Information Act. There was a statutory body also formed by the name of Central Information Commission, then State Information Commission. And what is the major objective of these particular commissions? To grant people information that they have been looking for, if they are not very crucial for the national security of the state. Like let's say if I'm interested in knowing what is the personal income of the incumbent Prime Minister Narendra Modi or one of the elected representatives of my constituency, I may simply write to State Information Commission or Central Information Commission that I'm interested in knowing the monthly income or the overall income of my elected representative of my constituency, MLA or the MP. Then he or she may ask Competition Commission or Central Information Commission, why I'm interested in their personal thing. I'm saying it's not about the personal things. It's more about how much property they have acquired since they occupied the office. I want to know how much bribe they have taken because it concerns the public interest. So that means anything that deals with the public interest that may be inquired as under the right to information. Right to information became a very important tool for transparency under good governance. So that's why it is very important. So it is basically a statutory right since it is guaranteed by the Right to Information Act, okay, RTI Act. So I hope now you get an idea. You got an idea. And most of the time, many of the questions are being asked from this particular segment. Okay. So legal right is a very vague term. It is segregated into constitutional right and the statutory right. Constitutional rights are those rights which are explicitly mentioned in the Constitution. Okay, now it can be further classified into fundamental rights and the non-fundamental rights, but still lying under the Constitution. Fundamental rights mean part 3 of the Constitution. Like let's say if I say Article 32, right to remedies, right to constitutional remedies. In case of violation of a fundamental right, you can approach directly to Supreme Court. It will be regarded a fundamental right. It is mentioned in part 3 of the Constitution. But Article 226, right to approach to high courts in case of violation of a fundamental right or even a constitutional right. Even if a constitutional right is violated, then also I can approach to a high court under Article 226. So this Article 226 will come under this part, okay? A constitutional right, but not fundamentally assured. Now, what is a statutory right? Any right which is guaranteed to us by an act of parliament or any statute like the right to information. I hope Now you can tackle any question which is asked from this particular segment. Okay, this much faith I have in you all. Rest you will study in your polity segment also, so it will become more clear to you. Now, I already mentioned that the Supreme Court gave 7 basic rights which are intrinsic to right to property. So just look at insight into, just get a glimpse of it. Right to notice, or the duty of the state to inform the person that it intends to acquire its property. Before acquiring a land, before doing acquisition of the land, that state should give the notice to the person that we want to acquire your property, and this for this particular reason. Right of the citizen to be heard, or the duty of the state to hear the objections to the acquisition. As soon as the notice is served to me, I may raise my certain objections that there are sentimental values attached to the act, attached to the land. There might be something of crucial importance to me which the state is not willing to consider. At least whatever objections might be having, I should be having a right to be heard. Okay, I should not be denied the right to be even make my proposition or argument. That is known as the right of citizen to be heard. Right of the citizen to make a reasoned decision, or the duty of the state to inform the person of its decision to acquire the property. Okay. Duty of the state to demonstrate that acquisition is exclusively for public purpose. It is also covered. Like the state cannot do this thing that we want to make a big palace for the CM residence. Because chief minister, who is sitting as the head of the government, he decides to make his own palace, make of glasses, of all the gems, some Italian marbles might be used over there, and for that reason he decides to acquire a private property. So at least I should be given a right to make myself heard that, okay, you people are acquiring my land, you people are acquiring my private land, but for what purpose? If it is for a public purpose, then it's fine. But if you are simply acquiring the land just to make a palace for yourself for some private purpose of a state authority, then it is not a justified reason. Okay. Right to fair compensation of the citizen. The state cannot simply deny me of the right to my private land or something like that, simply by giving me some pennies. They can't say if the monetary value of my land, let's say it is 10 lakh, the government at least need to give me the market rate for it. It cannot say that since we are the government and you have to take whatever money we are offering you. Just take some 10,000 rupees to 20,000 rupees. What I will be doing with that? Okay, that will be kind of economic injustice to me. So right to fair compensation. Duty of the state to conduct the process of acquisition efficiently and within prescribed timelines. The acquisition needs to be covered within a specific duration of time. Right of conclusion, the conclusion of the acquisition proceedings leading to the vesting of a fair compensation. So these all basic rights are intrinsically incorporated within the vague framework of the right to property, which have been recently highlighted by the Supreme Court of India. So that's why right to property becomes very important for you. Okay.